that.
What did you say?
I said, here comes the lady who does that.
Oh, very good.
She's back.
Okay.
Okay.
All right. Are we ready?
Yes.
Good. The nature of lawyer craft in America, as per the United States Supreme Court. The practice of law cannot be licensed by any state. The name of the case is Schwer v. Board of Examiners. It's found at 353 U.S. 238 and 239.
Repeat that cite to me again.
Okay, Schwer, S-C-H-W-A-R-E,
Okay.
v. Board of Examiners, 353 U.S. 238, 239.
Okay.
Okay, the next point is, the practice of law is an occupation of common right. The case is called Sims, S-I-M-S, v. Ahearns, A-H-E-R-N-S. It's found at 271 S-W 720, 1925. That's the year, 1925.
Yes.
Got it?
Got it.
The certificate from the state Supreme Court only authorizes to practice law in courts as a member of the state judicial branch of government, can only represent wards of the courts, infants, persons of unsound mind. See Corpus Juris Secundum, Volume 7, Section 4. Certificate is not a license to practice law as an occupation, nor do business as a law firm. The state bar card is not a license. It is a union dues card. The bar is a professional association. The actors union, painters union, etc. No other association, even doctors, issue their own license. All are issued by the state. It is a non-governmental private association. The state bar is an unconstitutional monopoly, an illegal and criminal enterprise, violates Article 2, Section 1, Separation of Powers Clause of the Constitution. There is no power or authority for joining of legislative, judicial, or executive within a state as the bar is attempting. Bar members have invaded all branches of government and are attempting to control de jure government as agents of a foreign entity. It is quite simple to see that a great fraud and conspiracy has been perpetuated on the people of America. The American Bar Association is an offshoot from London Lawyers Guild and was established by people with invasive monopolistic goals in mind. In 1909, they incorporated this traitorous group in the state of Illinois and had the state legislature, which was under the control of lawyers, pass an unconstitutional law that only members of this powerful union of lawyers, called the ABA, could practice law and hold all the key positions in law enforcement and the making of laws at that time. Illinois became an outlaw state, and for all practical purposes, they seceded from the United States of America. The Bar Association then sent organizers to all the other states and explained to the lawyers there how much more profitable and secure it would be for them as lawyers to join this union and be protected by its bylaws and canons. They issued to the lawyers in each state a charter from the Illinois organization. California joined in 1927, and a few reluctant states and their lawyers waited until the 1930s to join, when the Treasonous Act became de facto and the citizens became captives. Under this system, the lawyers could guarantee prejudged decisions for the privileged class against the lower class. This was all made possible by the American Bar Association to favor the right and have unlawfully substituted them in place of constitutional laws. The Constitution was written in plain English, and the statutes passed by Congress were also in plain English, with the intent of Congress, how each law should be used, and not the opinions of various judges as the codes list. Any normal person can read the Constitution and statutes and understand them without any trouble. The public in California was shocked to learn that the state government has no control or jurisdiction over the Bar Association or its members. The state does not accredit the law schools or hold bar examinations. They do not issue state licenses to lawyers. The Bar Association accredits all the law schools, holds their private examinations, and selects the students they will accept in their organization, and issues them so-called license, but keeps the fees for themselves. The bar is the only one that can punish or disbar a lawyer. They also select the lawyers that they consider qualified for judgeships and various other offices in the state. Only the Bar Association or their designated committees can remove any of these lawyers from public office. The state legislature will not change this system, as they are also designated committee of the bar. On August 21, 1984, Rose Bird, Chief Justice of the California State Supreme Court, another of the Bar Association's judicial committees, stated in essence that the bar should determine the legality of all initiatives before they were allowed to go on the ballot. This is contrary to both state and federal constitutions, as well as the laws of this nation instituted by and for the people as a sovereign unity of independent states of we the people, not a fraudulent corporate entity of lawyers. This is a tremendous amount of power for a private union that is incorporated and headquartered in Illinois to hold over the citizens of California or any other state. The only recourse is through the initiative process and vote by the people. After the Founding Fathers had formed the Constitution, outlining the laws as to the way our government was to be run, Thomas Jefferson said, in essence, this proves that plain people, if given the chance, can enact laws and run a government as well or better than royalty and the blue bloods of Europe. The American people must stop thinking that lawyers are better than they are and can do a better job than they can before the courts of America. Under the common law and the laws of America, nowhere is it expressly given for anyone to have the power or the right to form a corporation. Corporations are given birth because of ignorance on the part of the American people and are operating under implied consent and power which they have usurped and otherwise stolen from the people. By right and law, they have no power, authority, or jurisdiction, and must be put out of business by the good citizens of America in their fight for freedom. The U.S. Constitution guarantees to every state in this union a Republican form of government. Any other form of government is forbidden. No public officer or branch of government can be limited to a ruling class of any kind, or the states become atrocities and not republics. Also, the lawyers have made themselves first-class citizens, where many public offices and branches of government are open only to lawyers. All other people are limited to only two branches of government and to only certain offices in those two branches of government, making all people who are non-lawyers into second-class subject citizens. When the courts belong to the people, as the United States Constitution requires, Article 4, Section 4, we, the people, will never rule against themselves. In these unconstitutional courts, foreign tribunals, hoodlum centers, men in black dresses that are unconstitutional robes of nobility, Article 1, Section 9 and 10, dispense a perverted ideology where the people are terrorized by members of the black robe cult, lawyers and lawyer judges in the courtrooms. The legislative branch of government does not have the constitutional power to issue court orders or any other kind of orders to people. As a fiction court or a court corporation for profit and gain cannot reach parity with a lawful man. Only presidents and governors, presidents and governors have the constitutional power to grant pardons. But lawyers and lawyer judges are unconstitutionally granting pardons with immunity from prosecution. Citizens are not permitted to act like people in the courts. The citizen, second class, is told that he does not know how to fill out fancy lawyer forms, that he is not trained in the law, that he does not know court rules and procedures, etc. This is unconstitutional lawyer system. Only hearsay substitutes, lawyers, not under oath, have access to the fiction for profit and gain courts, even though only sworn testimony and evidence can be presented in court. Anything else is a bill of attainder, not permitted under the U.S. Constitution, Article 1, Section 9 and 10. The U.S. Constitution does not give anyone the right to a lawyer or the right to counsel, the right to any other hearsay substitute. The Sixth Amendment is very specific that the accused only has the right to the assistance of counsel, and this assistance of counsel can be anyone the accused chooses without limitation. Lawyers and lawyer judges created unconstitutional lawyer system, pre-trial motions and hearings to have eternal extortionistic litigations, which is barbarity and also is in violation of the U.S. Constitution in Article 1, as this placed defendants in double jeopardy 100 times over. Defendants only have a right to a trial, singular, not trials, plural. When a criminal is freed on a technicality, he is freed because of a fix and a payoff, as a defendant can only be freed if found innocent by a jury, not by any technicality. Whenever a lawyer is involved in a case directly or indirectly as a litigant or assisting in counsel, all lawyer judges have to disqualify themselves, as there cannot be a constitutional trial. And also, there would be a violation of the conflict of interest laws, along with the violation of separation of powers and checks and balances, because officers of the court are on both sides of the bench. These same lawyer judges are awarding or approving lawyer fees directly and indirectly, amounting to billions of dollars annually, all in violation of conflict of interest laws. As long as there are lawyers, there will never be the Constitution or justice. There will only be mob rule by a mob of lawyers. Case law is unconstitutional, as case law is enacted by the judicial branch of the government. When a lawyer judge instructs, directs, or gives orders to a jury, the lawyer judge is tampering with the jury. He also tampers with the testimony when he orders the answers to be either yes or no. The lawyer judge also tampers, fixes, and rigs the trial when he orders anything stricken from the record, or when he rules certain evidence and the truth to be inadmissible. This makes the trial and transcripts fixed and rigged, because the jury does not hear the real truth and all the facts. Juries are made into puppets by the lawyers and lawyer judges. All lawyers are automatically in the judicial branch of government, as they have the unconstitutional title of nobility, Article 1, Section 9 and 10. Officers of the court, citizens have to be elected or hired to be in any branch of government, but non-lawyer citizens are limited to only 2 of the 3 branches of government. Lawyers, as first-class citizens, can be hired or elected to any of the 3 branches of government. Lawyers, officers of the court in the judicial branch, are unconstitutionally in 2 branches of government at the same time. Whenever they are hired or elected to the executive or legislative branches, this is a violation of the separation of powers, checks and balances, and the conflict of interest laws. Commonwealth attorneys and state attorneys have taken over the grand juries from the people, where the people are denied access to the grand juries when they attempt to present evidence of crimes committed in the courtrooms by the lawyers and lawyer judges. The U.S. Constitution, being the supreme fundamental law, is not and cannot be ambiguous as to be interpreted, or it would be a worthless piece of paper and we would have millions of interpretations, unconstitutional amendments, instead of the few we now have. That is why all judges and public servants are sworn to support the U.S. Constitution, not interpret it. Under international orders, all lawyers, whether they left law school yesterday or 50 years ago, are exactly the same. All lawyers have to file the same motions and follow the same procedures in using the same unconstitutional lawyer system. In probate, the lawyers place themselves in everyone's will and estate. When there are minor children as hires, the lawyer judges appoint a lawyer, a child molesting Fagin, for each child, and at times the lawyer's fees exceed the total amount of the estate. An outrageous amount of tax money is directly and indirectly stolen by lawyers, money that is budgeted to county boards, school boards, and other local and federal agencies eventually finds its way into the pockets of lawyers, as all of these agencies are tricked and forced into eternal extortionistic litigation. Can we take a break? I have some more points I need to prepare.
How much time do you need, Mr.?
Oh, just 10 minutes.
Yeah, that's fine.
Thank you, appreciate that.
You're welcome.
Okay.